I have the honor of introducing our speaker this evening. We're very, very lucky to have David McGuire, the Executive Director of Connecticut's ACLU, speaking to us tonight. David J. McGuire went to Western New England University School of Law, where he graduated with honors. After law school, David clerked for the Connecticut Superior Court system. After that, David joined the legislative policy team at Connecticut ACLU. In 2007. In 2016, David was appointed executive director. In his now 13 years with the ACLU of Connecticut, David has litigated cases to protect incarcerated people's rights, separation of church and state, and free speech rights. We are delighted to have the executive director of the Connecticut ACLU speaking to us tonight. David, thank you so much.
What I thought I would do tonight is spend 15 or 20 minutes going over 3 subject matter areas that are topical and where we've done a bunch of work over the last 4 to 5 months, really during the COVID period. Those areas are voting rights, the rights of incarcerated people here in the state of Connecticut as they deal with COVID and beyond, and criminal justice reform. So I'll start with voting rights. Clearly, people are focusing on the election. It is a very important election for our state and our country. The COVID-19 pandemic makes voting even more difficult than usual. We're lucky to be in a state where there's not a lot of voter suppression or intimidation. But what a lot of people outside of Connecticut don't know is that we have some of the most restrictive voting laws in the country. And that's because of our Constitution. Our state Constitution is quite limited in terms of early voting and absentee voting. And in our state, it takes quite a lot of effort to change the Constitution, which is generally a good thing. In many cases, our Constitution is more protective than the federal Constitution. But in areas like voting rights, it is in some cases a stumbling block to larger voter access bills. So for a number of years, we have been pushing with lots of other ally organizations and people on the ground. So over the last couple of years, we have done a couple of things to expand voting rights. For example, you can now register on election day. That was not something you can do prior to a couple of years ago when a bill was passed, which we helped champion. And right when the pandemic hit in March, we realized quickly this is going to have a dramatic impact on people voting in the primary and in all likelihood, the general election in November. We pushed the governor's office and the secretary of the state to do something about the primary in the summer, and they ultimately did it by executive order. The governor pushed the primary to August, and then later made an edict from the executive branch saying you can vote by absentee ballot for no excuse because of the COVID-19 epidemic during the primary. We were insistent that that same protection be made available for the general election because of all the uncertainty and the fact that a lot of people are vulnerable to COVID-19 or live with someone that is. So they may have their right to vote chilled based on the pandemic, which is not right. So after quite a bit of advocacy, in July, we filed a lawsuit on behalf of the NAACP of Connecticut and the League of Women Voters. We made 2 claims in federal court. We made one claim that not allowing no excuse absentee voting was a violation of people's fundamental right to vote. We also made a claim that if we did not allow no excuse absentee voting in Connecticut, it would violate the Voting Rights Act. That essentially people that have been discriminated against and prevented from voting for decades on purpose, mainly African American people, were going to be disenfranchised at higher rates yet again. Ultimately, I think in part due to the lawsuit and advocacy from a number of groups, the legislature did step up in the special session and did ultimately pass a bill that allows people to vote by absentee ballot for the reason of COVID-19 illness, which is a step in the right direction. The other thing that they did significantly, which was kind of snuck in there, and we're really grateful that it was, we advocated for this to be added. You are now able to vote by election day registration, regardless of when you get to the polling place. I don't know if you all remembered seeing articles or news stories after the last few elections from Bridgeport or New Haven or up in Storrs, Connecticut, where UConn is, where essentially the poll workers would tell people if you are not registered by 8 p.m. when the polls close, you cannot vote, which was never the intention of the legislature. They intended it to work just like voting. As long as you're in line by 8 o'clock, they will let the queue go through. It takes until 11 o'clock as the line for voting is wrapped around town hall, then you should be able to cast your vote. That is now absolutely crystal clear in the law. We are also pushing very hard for alternative options. We recently were part of an effort to make clear what the statute didn't, that you can not only vote in those boxes by putting your ballot in there, you could also register for an absentee ballot by putting your registration materials in that box. And my wife and I just got ours today. So that was an area where we use what we call an integrated advocacy tool. We use all of our departments, our litigation, our legislative work, and our political action work to get at shared goals. And this is one where you saw a lawsuit filed, you saw us lobbying legislators through our action network and doing quite a bit of voter education through webinars and things of that nature, and ultimately to get the fix done. People will be able to vote freely in the November election. The other big topic that the legislature took up in this special session was one that we've done a lot of work on. That's police accountability. We as an affiliate of the ACLU have worked on that issue for decades. We actually recently went through our archive and found cases that we had filed in the 60s around police brutality back then. So this is something that we have a long history of working on. And for the past several years, it was almost impossible to get any meaningful progress on what people consider police brutality or police violence. Part of that is because every legislator in the state has at least one police chief and one police union in their district. Many have multiple of them. The reality is that it is one of the strongest lobbies at the Connecticut legislature. It's very hard to advance anything on police transparency or police misconduct unless there's a tragic event that unfolds, usually literally during the session. You need that kind of a tragedy to spark enough outrage to get an open mind from legislators to pass something. And unfortunately, we had that window again this summer because of the murder of George Floyd in Minneapolis. It sparked a conversation that we and others on the ground in lots of cities, including Stamford and Bridgeport and Norwalk in Fairfield County, have been calling for years. And that is, meaningful reform to the way that police are held accountable when they violate people's rights and hurt or kill people. So we worked with legislators, mainly from the Black and Puerto Rican caucus, on what was a comprehensive omnibus bill. Those are pretty rare in Connecticut, but this is a bill that I think ultimately it landed at around 60 pages and took on many, many topics, from training of police to qualified immunity, lots and lots of topics. There's a couple that I'll hit on for you because they're significant, and then there's one that I want to mention because the legislature did something that they thought did something, but actually doesn't, and will likely need some advocacy to actually work the right way. And I wanted to educate you all about that issue. One of the things that it does significantly that people don't know about, it really wasn't widely talked about, was it bans the use of consent searches. In case you all don't know, Connecticut has the most robust racial profiling data collection in the country. It's taken some time to get there, but right now all police departments are submitting their own data, often in real time, that shows researchers who they're stopping, and we're able to figure out trends around racial profiling. It was not a surprise to us to see that racial profiling does in fact exist in Connecticut. What was most shocking was that Black and brown motorists are not only stopped a lot more, they're searched a whole lot more, and a lot less contraband is found. And that is because officers are often going on fishing expeditions or working off their own bias in determining that someone should be searched. And one of the ways they get to search a vehicle is oftentimes by consent searches, where the power imbalance in a traffic stop is undeniable. When they say, "You don't mind if I search your vehicle, do you?" A lot of people, even if they're not comfortable with it and know that the officer does not have any probable cause to search their car, will say, "Yes, you can." What that ends up doing is eroding the public's confidence in police, particularly around Black and brown motorists, and oftentimes leading to tragedies. I mean, you've probably seen dozens of videos where routine traffic stops end up in someone being shot or chased or killed. So now in Connecticut, it's actually unlawful for police officers to ask for a consent search. Someone can on their own offer one, but that has to be either documented by body camera footage or the person has to sign something. So this is a very big step forward in terms of curbing interactions and hopefully creating a more fair playing field for people as they deal with police. There are some major pieces around police certification. Police right now face virtually no chance of losing their ability to be a police officer if they're reprimanded or sued and even found civilly liable for hurting or killing someone. This can potentially change with some certification changes. The board that ultimately decides on that is still very much stacked with law enforcement officers, which creates concerns that it will not change even though the regulations have changed, but it's a step in the right direction. And probably the most important piece in my mind is this piece around what they call the Office of the Inspector General. The legislature saw fit to create a completely new office that's sole charge is investigating killings at the hands of police. Around 25 people have been shot and killed by police since 2000. None of those officers have ever been charged criminally. Not that criminal charges are the answer to everything, because we're very much about decarceration. But when police officers know they face virtually no personal liability for hurting someone, have almost no risk of losing their job, and then on top of it have no chance to be found criminally liable, it creates a mentality where they feel like they're untouchable in some ways, and that is deeply problematic for the public safety. This office will be completely independent. It'll be in its own building and have its own investigators and its own attorneys. And we were quite excited to hear about this going forward, only to learn that the way that the statute was written, it only allows someone to be hired that is currently a prosecutor. That kind of undermines the credibility of this office from the start. But in order to have the real change and the independence where there's essentially an inspector general who's willing to go forward with criminal charges when they're justified, you need that separation. So we are hoping to accomplish that. I do believe most legislators thought that this was a position that, for example, a judge might run for, or a criminal defense attorney might run for. So that's one piece that is quite significant that we hope to get fixed. The last thing I'll leave you with on policing is around the defund movement. What the ACLU of Connecticut believes is that there needs to be a true reimagination of what police do and what their role is. Police are tasked with doing a lot of things, some of which they're not equipped to do and they're not very good at doing. And many of them are tasks that they don't want to have anything to do, like responding to mental health calls, for example. We are very much in the mindset of what we call divest and invest, the idea of really reevaluating what police do, why they do it, and figuring out whether there are other entities that can do that work in a better way and in a more life-affirming way. The best example is mental health calls. There's no reason to send a police officer to a call when someone is clearly in mental health distress, and that is the nature of the call. And finding ways to reinvest in communities where some services can really prevent those criminal justice interactions. We're actually doing some polling of some cities in Connecticut to figure out what residents want, where they want their dollars to be, and what they think of the police. Stay tuned. You'll see a lot more from us on that, but we will continue to have a very forward-facing and robust presence on police reform issues, because it is a huge issue here in Connecticut. And then the last area that I'll touch on has to do with criminal justice reform, and most recently around the conditions in Connecticut prisons and jails during COVID-19. One of the first areas that we jumped into was prison conditions. Before there was even one documented case of COVID in Connecticut, we were on the phone with the Commissioner of Correction and writing letters to the governor and the chief state's attorney, urging them to take action to create a plan to deal with people inside our prison system who we knew were really sitting ducks. They were in institutions that really needed a plan drawn up well ahead of the virus coming to our state. We offered to work in a collaborative manner on that and essentially got crickets, and we're later told we got this under control, and they didn't have it under control. It really spiraled out of control very quickly. Once it got into the system, the rates were going up dramatically. At one point, if you created a town that's population was the DOC population, it would have had the highest rate in the state of Connecticut. Ultimately, we were forced into filing two different lawsuits. Actually, we filed one in state court and one in federal court. The federal court case was a class action lawsuit, which we ultimately ended up reaching a settlement with the DOC in the state of Connecticut on. So we're in the process now of still doing a lot of work to make sure that that consent decree is followed through on. And we've got a lot of indications that unfortunately it is not being followed through on. But one of the silver linings of COVID is that our prison population is down dramatically. From a height of about 20,000 12 years ago, we're now down to less than half of that. We're down around 10,000 as a full population. We still have a lot of decarceration to do, but our efforts now are turning to make sure that we don't balloon back up to the pre-COVID levels. Because if we're able to keep public safety now, why reincarcerate those people? The ripple effect is really tremendous, mainly on Black and brown communities. So you'll see a lot from us in terms of finding ways to merge some of our police practice work with our decarceration work. Because the front end of the system is really where you want to focus. You don't want people coming into the system that don't need to. So we'll be doing a lot of work around that. It has been a very hectic 6 months. Out of my 13 years with the ACLU, this has by far been the most busy and intense period, all with us working remotely. It's been a wild ride.